using your creativity to build a winning venture or product is important for entrepreneurs. But after putting forth a tremendous amount of effort to build something, protecting your inventions and brand become critical. Thankfully, the U.S. Patent and Trademark Office exists to help inventors and business owners stake their claim for the intellectual property they develop. It is America's innovation agency. Just as veterans answer the call to defend our nation, the USPTO defends business owners, their work, and ideas. Joining us today are Christopher Harris, Ray Vasquez, and the team at USPTO to talk about intellectual property basics and answer your questions. Welcome, Ray.
Thank you, Dan. Can you guys hear me okay?
Got it.
Thanks. My name is Reynaldo Vasquez. You guys can call me Ray. I am the Texas Regional Outreach Officer here for the USPTO Texas Region Office. I'm very happy to be here today. Myself, I'm an Army veteran, still currently in the Army National Guard. I used to work for the U.S. Small Business Administration doing economic development for about 11 and a half years. Now I transitioned over to USPTO to help manage the outreach activities that we do throughout the year. So I'm happy to be here teaching you guys on intellectual property, what USPTO is, how it works, and the resources that we have, because a lot of people do not know that we have a lot of resources for inventors. They're looking to go after patents, and even small businesses are looking to go into patents and trademarks as well. So with me today, I do have Christopher Harris, Michonne Hunter, and Carmen Lyles Irvin, and I'll pass it over to them to do a quick introduction, and then we can get started with the presentation. Chris?
All right, thank you, Ray. How you doing? My name is Chris Harris. I'm a patent examiner at the USPTO. Been at the PTO for about 10 years, but however, I've been wearing a different hat for the past year as an outreach coordinator. So I wanted to detail our career development opportunities here. A little bit about myself. I work full time out of New Orleans, remote here. I am an electrical engineer by trade, but during my time at LSU, I served in the United States Marine Corps Reserve. So I am very ecstatic to be here to deliver this presentation. I will be going over the intellectual property basics, and I believe I might be covering the resource section. But since time is limited, I want to pass it over to Carmen and Sean so that they can also introduce themselves. Carmen?
Good afternoon, everyone. My name is Carmen Lyles Irving. I am also an outreach coordinator supporting Reynaldo out of the Texas Regional Office. While I am not in support of outreach, I am a patent examiner in TC 1700, which is chemical materials, where I examine fuel cells and batteries as a patent examiner. I've been here a little over 10 years, and I am outside of the Atlanta metro area. Thanks to everyone for their service. And good to be here today. Michonne?
Good afternoon. My name is Michonne Hunter. I also am a detailee with the Texas Regional Office. Outside of that, I'm also a primary patent examiner in 2484, which is video recording and reproduction. I have been with the Patent Office for about 17 years now. And also, thank you for your service and thank you for having us today.
Okay, let's go ahead and get started with the presentation. Chris, can you pull it up? There we go. So we are the U.S. Patent and Trademark Office. Today we'll be talking about intellectual property basics to give you an overview of what intellectual property is, what the USPTO does, and some of the resources that we can provide. Next slide, please. So the functions of the USPTO are really our role of the USPTO is to grant patents for protection of inventions and to register trademarks. So we typically will work with specifically patents and trademark registrations, but we also do foster and promote the industrial and technological progress of the nation and strengthens the economy. So we do look to foster innovation, create atmospheres of education and IP, because we do believe if people do get educated in intellectual property, they tend to use it more, and not only protect it but be aware of what it is. So we do disseminate the information, education, and then we develop and sharing of new technologies worldwide. One of the other common factors that we do, and a lot of people don't know, is that our director advises the President of the United States. So she is politically appointed, but for any IP matters, our director is the IP counsel per se for the United States President. So it's just good to see. So not only on patents and trademarks, but also other intellectual property aspects that we'll talk about today. Next slide, please. So the USPTO is mainly focused on patents, and a lot of it is because of the quantity that it takes to do. So to give you an overall picture, we have about 13,000 employees that are patent examiners, and about 8,500 of them are patent examiners. So it gives you an idea of how much focus we put on patents. As you saw right now, Chris, Michelle, and Carmen, all patent examiners in different technology centers, and a lot of it is because we want to get subject matter experts to be able to understand the technology in the field that you're in. We also do have the trademark examining attorneys, which are trademark attorneys by trade. And we do also have administrative patent judges and trademark judges to be able to handle any of the process with patents and trademark appeals. So it's good for you to understand how the USPTO works and some of our personnel. Just to give you an overview of fiscal year 22 numbers, 646,000 applications were filed last year, and 361,435 patents were issued. So it gives you an idea of the workflow that we get every year. Just to give you an idea of the overall situation, we continue to increase on patent and trademark applications, which is a good sign for the economy because we continue to foster innovation, and we continue to see small businesses and inventors, even large corporations, foster innovation and protect their intellectual property. For trademarks, we do get a little bit more applications, about 787,000, and 453,000 certificates of registration were issued last year. It kind of gives you a good workflow of, USPTO, the employees, and what kind of patent and trademark applications we see every year. Down here, we do see the USPTO headquarters in Alexandria, Virginia. Thanks to, you go on to the next slide, but thanks to the Americans Invents Act, we have been able to expand throughout the nation. So our office is the Texas regional office, but we do have other regional offices around the nation that cover their respective states. So we have the West Coast region, which is also known as the Silicon Valley Regional Office. We have the Rocky Mountain Region Office, which is in Denver, Colorado. Texas Region Office, which is ours, which we're based out of Dallas. The Midwest Regional Office is based out of Detroit. And then we still have the East Coast Regional Office, which is in conjunction with headquarters. The West Coast Regional Office is actually in San Jose, California. So just to let you know, we're more accessible to you guys. We're able to work with our stakeholders a lot closer and educate our public a lot better, thanks to the regional offices in the Americans Invents Act. You go on to the next slide, Chris. Just to highlight a little bit of the Texas regional office, and a lot of the regional offices have similar structure. We do have public search facilities for you guys in case you wanted to come in and use some of the public search tools that we have. As we'll talk later, most of them have gone online, which is a little bit easier for individuals to use, but there's always an option for you to come into the office and be able to get technical assistance here. We have examiner interview rooms in case you wanted to use them as well. Hearing rooms that you can participate if PTAB or TTAB is having any hearings, and public meeting space as well. So it's good for you to understand how the regional offices work and what we are and what we can provide. So next slide, please. I'm going to talk briefly of IP in the U.S. economy and how it connects and the power the intellectual property has really. So throughout history, we've seen the U.S. patents grow. Our first patent was in 1836. Now we're up to 11 million patents, which is great to see. And you can see the increase in generations. And really, we continue to increase even now. Like I mentioned before, people are understanding intellectual property more, and therefore they're able to understand it and protect it and see the value on it. If you go on to the next slide, you can see some of the numbers through the economy. There we go. So IP intensive jobs are about 47 million in the industry itself. 41% of IP industries share a total US GDP of 41%. You're looking at the value of IP in intensive industries is about 7.8 trillion. I do see that you do see here that if you are in IP industries, intensive industries, you also do get paid higher. The wages for workers are 60% higher, so you get about 1,517 a week in dollar value. And we also do have revenues on licensing rights of about 115.2 billion. So it gives you an aspect of how strong the IP intensive industries are, thanks to the intellectual property and some of the options on licensing as well, because you also do have 28 industries driving revenues from licensing alone. So these are statistics that we provide through economic reports that you can find on our website. You can also reach out to us, but we're pretty transparent. We have accountability reports and economic reports that we do yearly, just to show the public, what we're doing, employees wise, patents wise, and even how it's affecting the economy. Because ultimately, we want the youth economy to foster innovation and to create better jobs, better stability, and really be at the forefront for the world in intellectual property. You go on to the next slide. So this kind of showed you some of the benefits of having a patent. Startup companies that have a patent are far more likely to be successful in raising funds for new product development and expansion of products of production than those that have not secured intellectual property protection. When used as collateral, a patent increases venture capital funding by 76% over 3 years and increases funding from IPO by 128%. The approval of the startup's first patent application increases its employee growth by 36% over the next 5 years. After 5 years, a new company with a patent increases its sales by a cumulative of 80% more than the companies that do not have a patent. So you can see the benefits, patents bring in. This is what we talk about IP portfolios. Individuals are able to use those patents and trademarks to expand in venture capital funding and have more probabilities of success. We also do have more statistics that we can share, but just to give you an overview of what a patent can do for your company. So next slide, please, Chris. So from here on, I'll pass it over to Chris. Chris will be talking about intellectual property and the 4 buckets of IP. But feel free to ask questions, throughout the presentation. You have myself, Michonne, and Carmen monitoring the chat box. So any questions you may have, feel free to put them in there, and we'll make sure to respond to them. Chris?
All right. Thank you, Ray. As I said earlier, my name is Chris Harris. I will be going over the intellectual property portions of this presentation. We'll be covering patents, trademarks, copyrights, trade secret, what is intellectual property, as well as resources that the USPTO provides. This will be a lot of material to cover in a 30-minute time span. So please use the Q&A feature. You will get a copy of the presentation. So if something hasn't been highlighted, you will be able to, go back to it once you get the chance. So jumping right into it. So intellectual property. What is intellectual property? Intellectual property, you can break it down into 2 words, right? IP, you can consider it as an asset. So on the left side of the slide, you see 3 images of ideas, thinking, innovation. So that's what intellectual is, creations in the mind. And you have property on the right, and you see, a home for sale, a car. So things that you can do with cars, homes, you can lease them, you can sell them, maybe license them. You can do the same thing with intellectual property. So intellectual property, when put together, combines to form creations of the mind that may be protected by certain intangible rights. So the next slide goes over the 4 different types of intellectual property. The first 2 patents, trademarks, that's the bread and butter of the USPTO. The USPTO, we grant patents and register trademarks. The next 2 categories are copyrights and trade secrets. The next slide is a great representation of thinking what exactly is intellectual property. So many of you are probably looking at the stream through maybe your phone, maybe a laptop, but intellectual property is all around us. So this example shows an image of the Samsung Galaxy Note. Looking at this device, you can see that there's a stylus. The stylus has Samsung trademarks written on it, as well as on the phone. You have the screen that's covered within there's a semiconductor within the phone, battery, camera. These are all patents. The manual that comes with the device, or the ringtones that are installed on the device, well, those are protected by copyrights. The shape of the stylus, the shape of the phone, those are design patents. In terms of trade secrets, question marks represent the secret being a secret. So to maintain a trade secret, it has to be unknown from the public. Moving to the next slide, we're going to jump right into U.S. patents. So what is a patent? A lot of people have a lot of misconceptions of what a patent isn't, but the slide shows, 5 bullet points. A patent is going to be something that's granted by the U.S. government to an inventor. It's going to be granted for a limited time, usually 20 years, or 15, depending on the type of patent. You receive this as long as you exchange public disclosure of your invention. It's territorial, meaning that receiving a patent in the United States only protects you within the United States. If you want protection in other foreign countries, you will have to file with those offices. And then in general, it's a new way of doing something, or offer a new solution to a problem. So the interesting thing is, especially with today's class, being catered towards veterans, there's actually 3 inventors that prior Navy that were inducted into the National Inventors Hall of Fame, such as Lewis Latimer. He invented the evaporative air conditioning, as well as improving a process for manufacturing carbon filaments and light bulbs. So that allowed for affordable and safe incandescent lighting that was brought to the world. He also improved toilet systems for railroad cars. You have Frank Sprague, who contributed to the development of the electric motor, electric railways, electric elevators, as well as Lloyd Conover, who was the inventor of tetracycline, which was the oral antibiotic, and it was the first antibiotic that was made by chemically modifying a naturally producing drug. I say that to say, you as an inventor, you make you don't know what contributions you can make to the world. So a great example of this is, you see the image in the top right hand corner of a man that's sitting in a chair with a rod in his hand to control his television. Well, a patent was issued for a TV control device, but we know that this is not the first remote control. Actually, the company Zenit developed this in 1956 using ultrasound or sound waves to control the channels by putting these waves above the range of human hearing. But since infrared technology wasn't developed, a solution to a common problem had to be created. So with the TV control device, the objective of it was that it provided a device of simple structure, which was inexpensive to manufacture. It utilized it was utilized with facility and convenience, and it was less expensive than its electrical and electronic counterparts. And it functions very efficiently, effectively, and reliably because it selectively rotated the dials on a television from an area distance from the set. So the real key thing about this is the inventor Chris Michaels, he provided a solution to a problem. Even though it wasn't something new, he offered the new way of solving it, and that new way, was not patented, or it was not developed, and he received the patent. Obviously, since the 70s, infrared technology has become a mainstream item, as well as new wireless technologies for controlling devices. But you should not be dejected from pursuing opportunity for an invention because it may not be considered a brand new way of doing something. So the next slide talks about the formal definition of a patent. And as we can read from the slide, it's essentially a grant of property right for you as an inventor that excludes others from making, using, or offering from selling, or importing the invention in the U.S. So a big misconception is people think that when you receive a patent, it's a right for you to do this. But no, it's not. It's a right to exclude others from doing it. So moving to the next slide, we're going to go over the different types of patents. So the most common patent that's filed at the USPTO is the utility patent. So what the utility patent is, it can be granted to anyone who invents or discovers any new or useful process, machine, article, manufacture, or any new useful improvement thereof. So it's granted 20 years from the date of filing. And it covers, as I stated on the slide, processes, machines, article manufacturing, composition. So, these would be like maybe a new method of doing something. Maybe the Samsung device that we discussed, will be a machine. Article manufacture could be, a candlestick or a broom. Something that's created through artificial means, as well as composition of matter. The antibiotic that I discussed earlier. So the interesting thing about this is you can see from the slide that there is a image of a picture of Abraham Lincoln. Abraham Lincoln was actually the first president to receive a patent for a device that was manufactured. He was the first president to receive a patent for a device to lift boats over shoals, but he never manufactured it. So just because you have an idea, you can receive a patent, but you do not necessarily need to manufacture that idea. The next slide discloses design patents, and these protect the ornamental appearance for an article. This can be like the shape and configuration, or surface ornamentation applied to it. Fonts could be considered design patents. You can see the example of the shape of a Coca-Cola bottle. But as I said, it protects the way a product looks. But the key difference is 15 years from the date of grant is the protection that you receive versus 20 years from the date of file is the protection you receive for a utility patent. And the last patent, not as common, is the plant patent. So it protects newly invented strains of sexually reproducing flowering plants, for example, or fruit trees. But it's provided 20 years from the filing date. So it's not as common. I mean, you can see from this image, this was a plant patent that was issued in 1953, but it's plant patent number 1207. So not as common, but a common thing that a lot of people will love to know is, hey, I have an idea. How do I transform that idea into a patent? So typically, if you have an innovative idea, you want to search this idea, and the best way to do a search is you can use Google Patents. You can use the new search tool that we have. We will actually go over it towards the end of the presentation. But you want to do an internet search to make sure that your idea is actually something that's new, novel, or an improvement. So once you do the search and you say, hey, I may actually have something, then you're able to file an option, and this is optional, but provisional application. The provisional application is like a placeholder. As I said earlier, to file the utility patent, which will be the non-provisional portion of it, it's granted 20 years from the date of file. So this provisional application is not really cost saving, it's cost delaying, but it gives you the opportunity to, really search that idea, work on your product. You can pitch it to inventors or investors. As you see in Shark Tank. You can also use the word patent pending, but it doesn't trigger any statutory bars that will result in losing your patent rights. So once that provisional application, the year passed and you determine, hey, I may have something, then you will file a non-provisional application. Non-provisional application is submitted to the USPTO. After about 18 months, give or take, it'll be filed to the docket of examiners such as myself, and then we'll review the application and we'll determine whether or not this is something that can be patented, or if there aren't any other things that can be objected or rejected to it. But through negotiation with your attorney, a patent is resulted from this non-provisional application, And then once you have it, you have 20 years of protection from the date of filing, which will allow you to enforce it and protect your intellectual property rights regarding your patent. So that covers the pathway to a patent. I'm gonna pause briefly. Actually, no, I'm sorry. We're taking questions at the end, so I'm going to jump right into trademarks. So trademarks, what is a trademark? So if we read this slide together, we can see a trademark is a word, phrase, combination of words, phrases, symbols, or designs that identifies and distinguishes the source of the goods of the party from those of from those of another. And a service mark is actually the same thing as a trademark, except that it identifies and distinguishes the source of a service rather than the product. So trademark rights may be used to prevent others from using a confusingly similar mark, but not to prevent others from making the same goods or from selling the same goods or services under a clearly different mark. So some examples of trademarks are words, they could be designs. I'm not sure how many of you keep up with the latest legal news, but there was a infringer who utilized what can be considered a trademark of Nike to try to design a shoe, and they're being sued. Another famous case that's going on involves the Birkin bags and Meta Birkin, and whether or not it's the infringer has a right to utilize that. But those products, that's what trademark protection provides you. It allows you to protect your brand and then distinguish your brand from those of others who try to imitate or make a use of it. So some other common trademarks, or well, actually not as common, or maybe not traditional, is the better word to say, could be colors. So you have Tiffany blue, UPS brown, John Deere green, as well as scents, Verizon and Play-Doh, even sounds. The Pillsbury Doughboy, NBC, the Mario coin. Motion is actually covered under non-traditional marks. So the finger pushing towards the Pillsbury Doughboy or the Lamborghini doors, the way they open, are considered things that could be trademarked. And then you have trade dress. So trade dresses, they are a type of trademark that refers to the design of or packaging of a product. It is intended to protect the consumer from packaging or appearances of products that are designed to imitate other products. But the trade dress must be distinctive. So that means that the consumer who perceives a particular trade dress as identifying a source of a product, it has to be like, so for example, you see the Doc Marten boots. We all know it has yellow stitching, welt, it's a two-tone groove sole edge, black fabric heel, Coca-Cola, the bottle shape, the interior design of an Apple store. All Apple stores look the same. I actually went to a conference a few months ago, and for their booth, they set it up identical to an Apple store, as well as the Hershey Kiss. The shape of the kiss, the way the flag comes out of the candy, are great examples of different trade dresses. But what's most important is, hey, I now know what a trademark is, but how do I know what's a strong trademark? The next slide, it gives some examples of those strong trademarks. So a strong trademark, it's important to have it because it's inherently distinctive. It means your trademark can quickly and clearly identify you as the source of your goods and services. So the strongest mark are fanciful words or invented words. You can see that Xerox, it's a word that was created. It actually took on a second meaning to mean copying. You have Microsoft. Microsoft associated with computers and software. Cisco. But another acceptable trademark are arbitrary words. So arbitrary words are actual words that have no association with the underlying goods or services. So think of the term Apple as we see. If an apple orchard tries to register the word Apple as a trademark for the types of apples they grow, their trademark wouldn't be registrable. But Apple has been registered as a trademark for computers. Apple computers is unique. Some other suggestions are, Gap, as well as BlackBerry. And then you have the suggested trademarks, and these are words that suggest some quality of goods or services, but they don't state that quality of goods or service outright. So consider quality of the goods, consider Coppertone, for example, for suntan products. The trademark gives the impression that using Coppertone suntan oil will make your skin shimmier like copper. Dry foot, it will dry your feet, as well as ever ready for batteries. It will keep your batteries charged for as long as you want. But while I gave you great examples of what are strong marks, it would also help if I gave you some examples of what are unacceptable or weak trademarks. So weak trademarks are hard to protect against competitors and are often not federally registrable. These include descriptive and generic marks. So a descriptive mark, it merely describes some aspect of your goods or services without identifying or distinguishing them. So some examples of those trademarks would be a creamy for yogurt, apple pie for pottery, and bed and breakfast registry for lodging reservations. And then you have as well as generic trademarks, which just they aren't trademarks. They are just merely common everyday names for your goods and services. So like in the first example, the Apple Orchard, who tried to register a trademark for Apple, well, that's literally the common name for their products. So it wouldn't competitors as well as consumers will not be able to distinguish, if we're talking about the product or we're talking about the actual business. So that goes over trademarks. I'm going to push right along to copyrights, and the one key thing is we at the USPTO, we do not deal with copyrights in great detail, but we do advise people on copyrights. So from the slide, we can see that copyrights is a form of protection provided by the laws of the United States to the authors of original works of authorship, including literary, dramatic, musical, artistic, and certain other intellectual works. So basically, pen to paper, it's probably copyrightable. So it's a copyright. It's a bundle of rights that gives the owner the right to make copies, prepare derivatives, distribute copies, perform the work publicly, and display the work publicly. So things that are protected by copyrights are songs, books, sculptures, movies, as well as works that are protected by copyrights, logos, product design and packaging, advertising and promotional materials, software source code. So a key thing to note is that you should be seeing a pattern here. There is some crossover between the different types of intellectual property. So logo can be both copyrighted and serve as a trademark. You can also get a design patent for it. Methods or processes executed by software code may be patent protected, while the actual source code is copyrighted. So a cool thing about copyrights too is it provides the longest protection. It's 70 years plus the life of the author versus the patents, which are 20 years from filing date, or 15 years from grant date, or trademarks, which are 10 years, but then you can renew them. So that concludes copyrights. We're going to jump right into trade secrets. Oops. Excuse me. Sorry about that. So what is a trade secret? A trade secret consists of information and can include a formula, pattern, compilation, a program, device, method, technique, or process. So to me, the most common definition of a trade secret, that information must be used in business and give an opportunity to obtain some economic advantage over competitors who do not know or use it. Excuse me. So some examples of trade secrets are common things that we either consume or we use. So Coca-Cola, there's a classic formula for Coke. Krispy Kreme, there's a secret yeast raising recipe that a French chef from New Orleans created in 1937. KFC, the 11 herbs and spices, is a trade secret. In fact, even the head chef at KFC claims that he doesn't know what it is. And then Google, it uses like a hybrid intellectual property protection for algorithm. So the way their Google page rank is, Google combats the manipulation of its page rank algorithm by link farms and other tools is a closely held trade secret, but their actual page rank algorithm is considered patent protected. So if we see for the next slide, we can see that patents and trade secrets are really two different sides of the same coin. With patents, you have a duty to disclose, whereas a trade secret, you have to keep your secret. Patent, you have you receive rights, but it's only for a limited time. A trade secret lasts as long as it remains a secret. There may be legal remedies should someone steal your trade secret, but there may be legal remedies should someone make you sell your invention without your permission. A trade secret can be engineered, whereas a patent can be approved upon in such a manner to distinguish it from the invention that may be patentable. But as I said earlier, the first remote control device has gone over many re-editions from the 50s until now. The last slide gives a nice overview of what we just discussed. It's a quick reference guide that you can utilize. And if you had a question in terms of what protection do I receive for these various intellectual property rights, what are the requirements? What does it protect against? And how long it endures for. So with that being said, that goes over. That's the USPT, the intellectual property aspects of it. The USPTO resources will be discussed. Ray, do you want me to go over this, or do you want me to transition it back to you?
Ray might be scrambling for his mute button right now.
Yeah.
There we go. Double mute here, right there. I can be a reliever there for you, Chris. No worries.
All right, thank you. And I'm sorry by going by this quickly. We just want to make sure we have enough time for questions at the end.
Yeah, and there's some good questions on the chat there. I think you can. We'll elaborate more on shortly after the
Okay,
resources.
sounds
So
good.
next slide, please. So we do have a lot of resources here at USPTO, and we want to make you aware. One of the things that we do recommend and a big resource is our website. We put everything in our website that we have. We try to be transparent to the public. I do recommend for you guys to subscribe to our newsletters. We send out the trainings that are coming up throughout the year. Any changes in IP law or changes within USPTO, we send out. So just in a way for you to stay informative. We do have the regional office that are breaking down through areas, but we also do have our headquarters and our comms team that promotes nationally. But that is something I definitely do recommend. So next slide, please. This is one of the tools that I was talking about earlier. We do have a patent public search tool now that's online. It's a lot easier. Before you had to go to certain locations like PTRCs and the offices, the regional offices to use this. And this new web-based patent search application is pretty much what the patent examiners are using. So it gives you a good idea of how to do patent searches. So I would say it's not the easiest thing to do. There is a trick to it. We do have trainings for that, and we can assist you and give you technical assistance. But the resources and the tools are becoming more accessible to the public, which I think is a great thing for inventors and small businesses, companies to use as well. So next slide, please. One of the popular trainings that we have throughout the year, we have this quarterly. We have 8 modules. It's called Path to a Patent, and we go over the process of how to get a patent. It's not the easiest thing in the world. I would say it's like 1 or 2% of the patent applications that get issued are actually pro se individuals that represent themselves. Most of them are done through professionals, but we do teach you the process so you can learn. And even if you have IP counsel, you're able to assist them more because you understand the process itself. But the Path to a Patent is one of the most popular programs that we have, and we do have it quarterly. So I do recommend if you want to learn the process to take the course itself, the training that we do. And it's webinar based, so you can do it at the leisure of your time. We do share the recordings for the most part. Sometimes we don't just because of bandwidth, but it's definitely a good program for you to learn how to do the path. Next slide, please. And we do have an Inventors Assistance Center. This is a 1-800 hotline dedicated for patent assistance. So anything that you may have questions for for filing the application, the process, feel free to give the assistance center a call and they can guide you as best as possible. One of the key things to remember is that we are USPTO, we're a government agency, um, but we can't give legal advice. That's one of the primary things that distinguishes us from the private sector. We can guide you and educate you and assist you as best as we can, but we have to draw the limit at legal advice. So just keep that into consideration when you're calling us or reaching out to us. We'll guide you, we'll help you do informative decisions, but legal assistance is something that we cannot do. Next slide, please, Chris. We do have patent fees. In our website that you can look into. I don't think I mentioned it in the beginning, but the USPTO is a fee-based agency, what that means is that we operate based off the fees that we collect from trademarks and patents. So we don't receive taxpayer funding. We still do have to report to Congress and ask for spending and all that, but it's just that the structure of the agency is a little bit different than other agencies. But we do provide an incentive for micro businesses, which are usually 500 employees or less. We do provide incentives if you file electronically. So it is something for you guys to consider for micro entities, which are going to be small businesses. If you're filing, it's a big incentive for you to have. This is one of the questions that came into the chat. Individuals asking for the IP fees if it's kind of costly. That's typically where the fees are going to be, or the costs are going to be when you're going after a patent or trademark. And not necessarily USPTO fees are pretty standard, but the legal fees for an IP attorney to actually draft your application, it can be pretty costly. So, and it really depends on what it is, on the subject, how complex it is, because I do have to make a case for the patent itself. So just take that into consideration. It's not something that we control at USPTO. It's in the private sector, and that can be costly. But I'll talk about some resources here shortly that you can hopefully use to help you leverage those costs. So next slide, please. So we do have an option for prioritizing patent examination. So that is what we call track one. It is an option for individuals to reduce the time of application to receive and get your issued. So it is something that you can get within 12 months. So it's really good option, but you do have to pay for it. It's kind of like a Disney Fast Pass per se. You just want to let you know that option is there. Next slide, please. So we do have a patent ombuds office, which helps you with any issues that you may have through the patent process. In case there's anything being stalled, any issues with the patent examiners, just know that there is an ombuds office to help you and serve as a third party in case there's any specific issues. And you can see the email and the phone numbers there. And like I said, we'll share these slides for you guys to have in reference. And of course, you can find everything within our website as well. So next slide, please. We do have a patent pro bono or a PTAB pro bono program, and this is to help resource inventors to provide legal assistance preparing an ex parte appeal to the PTAB. So the requirements are listed here, but this is a great program that we were able to develop last fiscal year to help individuals at the enforcement side. It is something that is new, and you do have to qualify, based on the house, the income requirement, the microentity status, the filing date, and take some trainings online. But it's a great resource because we kept on seeing feedback that this is something that was needed to help individuals with parties and appeals. So keep this into consideration in case you have an issue, something that can assist you later on in the patent process. Next slide. So talking about the pro bono program, this is our biggest pro bono service that we have. USPTO certifies organizations around the nation to help you with legal assistance to preparing the patent applications. So these are nationwide, so we do have coverage around the nation, all U.S. states and territories. You can find this in our website. You can also email the pro bono program itself. But if you go on to the next slide, here in the it actually go back one more. Yeah, sorry. So just keep in mind every state and territory has their pro bono program. So just you can contact them, get on their list, and see if they can assist you with your idea or invention. It does require income requirements, and the knowledge in the of the invention needs to be pre-screened. It can't be just it has to be something feasible. It can't just be an idea. So keep those into consideration. But I mean, if you're able to qualify for the PAM pro bono program, I would definitely do it because it helps you tremendously with the legal fees. Next slide, please. So we do have our trademarks team that provides a lot of trademarks trainings throughout the year. Trademarks a little bit more feasible for small businesses, inventors, and entrepreneurs because it's easier to understand. One of the popular trainings that they're coming up is December 13th. They'll be doing a webinar talking about the registrations involving NFTs, blockchain, and cryptocurrency. So very much virtual goods. So this is a good popular program that I wanted to highlight for you guys. Next slide, please. The most popular program within the USPTO, it has to be the Trademark Basic Boot Camps. And this one's very similar to the patent to patent, but it goes over the trademark process itself. This is something that you definitely want to look into, especially if you want to protect your name, your brand, your logo. And as Chris talked about, what the non-traditional trademarks are, in case you're looking into those unique selling propositions. Next slide. We do have a trademark assistance center, which is also a 1-800 hotline, and it's manned through trademark examiners. So very helpful for any questions you may have on trademarks itself and the process. Just keep in mind, we can't give legal advice. Next slide. And then we do recommend you create a USPTO account to help you access not only your files and status, but also links to the application, responses, any change of addresses that you may need. Next slide. It's a good way to keep track of your docket. We do have a trademark app as well. It makes it a little bit more convenient for individuals, especially for trademarks. There's different categories, so it gives you the ability to be able to track it a lot better. Next slide. We do have a website dedicated for startup resources, which is more for small businesses. Not only do we give you information with FBA and MBDA and SBDCs, which are organizations that we work with, the FBA being the U.S. Small Business Administration, but also things to consider and help you plan for IP success, from IP rights to funding and engaging with experts in your community. Next slide. We do have an IP awareness assessment tool, and this assessment tool is a questionnaire that helps you understand your intellectual property. You go through the tool, it's about 10-15 minutes, you answer the questions, and it can help you get a better understanding of intellectual property and which type of buckets you actually hit in your situation. Next slide. A lot of business advisors use this tool for their clients. We do have patent research, PTRCs, the patent and trademark research centers, which are trained librarians in the community to help you do patent and trademark searches. Trademark searches are a little bit easier, but especially the patents, they can be a little bit more complicated. So we do train these local community librarians to help you and assist these intellectual property needs throughout the nation. So just keep those into consideration. I know this public is nationwide, so PTRCs are very helpful. And usually step one, it's kind of like doing a business plan. You want to make sure that your patent, your prior art is there. And if your idea is already patent, it's probably not worth pursuing, but there's always the option of approve upon. So those typically most patents are approve upon patents. So next slide, please. Lastly, I'll talk about law schools. This is another pro bono service that we provide. We have over 60 clinics around the nation that provide legal services for pro bono assistance to entrepreneurs, small businesses. They do follow the income requirements, such as the pro bono one, but they can differ in every state. So keep these in mind. They have clinics for patents and trademarks, and these are pretty much law school students under supervision of a clinic supervisor with IP background that can help you with the drafting process of a trademark and a patent. So very good pro bono assistance that we try to provide and expand through the nation. Next slide. And this is our information. Feel free to reach out to us, especially with intellectual property. You may not want to disclose it in a public setting. So we're always open to one-on-ones. We can bring in subject matter experts and trademarks, patent, and even some copyrights to assist you in your questions and inquiries. Is there any questions that we want to bring up?
I think we do. I think we do have some questions. Chad Lasik had a question. It seemed a little bit more involved. A lot of the other ones were answered in chat. Chad, you want to come on?
My pleasure, but it won't let me start my video. I don't know if that's important or not. You don't really need to. Oh, there we go.
There we go, Chad.
Not that it's
now
a great view.
Now we know you're not a robot.
That's right. So good afternoon. I appreciate you taking the time to answer my question. So my question is regarding patent specificity. You used it as an example earlier, the mobile phone and all the little aspects of the mobile phone were patented, but the mobile phone itself wasn't. And so I'm sure there's companies that would love to have a patent on the mobile phone or the automobile, you know, as a big, huge blanket to create a monopoly, but that doesn't exist. I've run into some patents in areas that I'm currently searching that seem to be that broad. They're literally, they use language like anything, everything, made out of anything. You know, they're these huge, broad blanket kind of patents that seem to be, you know, really prohibitive, but I don't think are legitimate. I don't know. Just like we can't patent the automobile. So can you speak a little bit about how that works in terms of how specific it needs to be considered a unique product when there are similar patents, especially if there's really broad patents like that are out there?
Yeah, no problem. So when you look at a patent application, the name of the game is the claims. So the specification, it may encompass many varieties of what the invention can do or many ways to use it, but the claims actually specify the boundaries of that invention. So when you, if you do a patent search and you want to know whether or not you're infringing on something, you know, you need to look at the claims. So the claims, and then in terms of the claims, you're only able to receive one invention per application. So an invention cannot have, while it can disclose multiple, I guess, different inventions in the specification, the claims themselves can only specify one. If there was ever an application that was submitted that, you know, maybe there was a claims directed towards the radio within a car, but then there was claims directed towards controlling the speed of the car. Well, those are two different inventions and will have to be restricted out. But that's a little, I guess, different level than what the courses, you know, covering in terms of awareness. But it's, I guess, something good to know. So you know, like what exactly that assignee or that organization has for that actual patent.
That's a great one. Hey, here's a question for you. What if you've gone through this process and you feel like someone's violated your intellectual property? What are your options? What's your recourse? Do you have any recommendations on that?
I think I might transition it to Carmen because Carmen is the attorney on the team, but the USPTO, we do not handle the enforcement of patents. We only handle the issuance. But Carmen does have some, I think, perspective from an attorney's outside the USPTO, so I'm going to transition to her.
Can everyone hear me?
Yes.
Okay, perfect. So as Chris was saying, here at the PTO, we are more about the granting of the issuance of the patents, right? But if by chance, Dan, and everyone else on the call, that someone has a patent to issue, and from that point, if that is infringed upon, then what happens at that point? It's advantageous at that point for you to, for instance, go and seek probably more likely than not seek the counsel of an attorney, where they can help you with what's called an interference. And then if well, number one, you probably want to send a cease and desist letter, right? And that's then notifying that party that's infringing upon your invention, i.e. your patent, to say, FYI, this is my invention. It's, protected by this particular patent, and therefore please can discontinue infringing upon my patent. And usually, oftentimes that helps. If it does not, then you may have to move forward and have someone who comes into, sue that person in order to get them to discontinue infringement of your patent. Now, mind you, I'm not a litigator, so I know about it, but it's definitely not something that I have done. But I've helped assist with the litigation part of the process. But that's generally what you would do, is then seek patent protection and then sue someone who has infringed upon your patent. If that helps answer the question.
Absolutely. And one of the things that's kind of going on in the chat, not everyone on the social network sees the chat in Zoom. If you want to, sign up at patriotbootcamp.org to get on that list. But one of the comments that seems universal is protect yourself with patents, protect yourself with trademarks, but also it seems like the onus is on you to protect your own security, protect your information before it's patented, right?
I would say so. I think it's smart to be very proactive in trying to protect your intellectual property. Again, as you were saying, in order to protect an invention, the best way to do so is to file and seek patent protection in order to protect. And again, I got to be very careful here how I answer the question, because I don't want to give legal advice. I am, again, a registered patent attorney, but I know the PTO, and in these presentations, we want to share as much as we can without going into the purview of providing legal advice. But again, when you are seeking trademark protection, you have to worry about, for instance, whether you've used or not used your mark. And then again, there's ways to do that. So the best thing to do is to make certain that you're seeking out the protection that you need, whether it be patent protection, trademark protection, and or copyright protection. And you do that by filing with each of the respective offices. I hope that's a sufficient answer to that question without being too vague.
I'm forcing you to walk the line.
Yeah, the other thing I would elaborate on is also trade secrets are very important as well, and very relatable to small businesses and entrepreneurs. And those are just different tools that you can use in the legal system to protect ideas. Because you have your NDAs, confidentiality agreements, exit clauses, non-compete. So just keep those into consideration as tools, and this is where it helps to have an IP attorney understand it. Because if you're a restaurant per se, in like the KFC, it just that's your trade secret, your recipe. So you have to find ways to be able to protect that, and that's not necessarily going to be a patent.
I want to take. There's a couple questions that came in that are super relevant and super great. One is from Roy, and he's saying, "Okay, what if you're doing business internationally? What do you have to do to protect yourself at that stage?"
I can take that one. So USPTO and IP is territorial. If you wanted to get IP protection in another country, you have to go with their IP office. So Mexico has their IP, China has their own IP office, and you kind of have to understand the laws and regulations and the way each country works. But just take that into consideration. IP is territorial, so we could only enforce and cover USPTO and territories.
And a product be marketed back into the U.S. that we did not hold a patent in another country, but we exported to that country, and maybe that's more of an enforcement question. It's not relevant, but if our design and our IP was ripped off by a foreign country and been marketed here, would there be legal recourse?
We do have IP attaches, which is a resource here at USPTO. They serve in U.S. embassies around the world as resource partners. So we have 3 in China, just because China is a big market and we have a lot of issues. So if it's something, we can connect you with them as well to see what legal resources they can provide or assistance, because they know the countries a lot better than we do. But we do have that specific resource here within USPTO. We're glad to
Thank you.
connect you with those, Roy.
Thank you very much.
Hey, thank you so much. We're running out of time here. I do want to thank the team at USPTO for a great presentation, important information. Carmen, Michon, Ronaldo, Christopher, you were fantastic. You represented the organization very well. And thank you for the way you serve our country and entrepreneurs. I want to set a quick reminder. Applications are still being accepted for DAV Patriot Bootcamp Winter 23. That's going to be here near Cincinnati at DAV National Headquarters, February 8th through 11. You can register at patriotbootcamp.org. The application deadline, however, is tomorrow. Fortunately for procrastinators, it's not a painful process to sign up, so you can do that at patriotbootcamp.org. You can also sign up for notifications so you can get in the chat, the Zoom chat with Patriot Bootcamp patriotbootcamp.org. And thank you all. If you're looking for help, resources, or great charity to support for your year-end giving, visit dav.org. Thank you, USPTO, and thank all of you for tuning in. God bless you.